First and foremost, I want to thank Ayodeji and Felix for doing a very wonderful job in explaining and distilling the very important issues with respect to players, the contract, and the RSTP. I must say that was a very sound analysis. But I'd like to also add that specifically as it concerns football associations around the world, I think sometime in November 2008, yes, FIFA sent a letter to all its member organizations and football associations, which that letter stated the minimum contract requirements for every player contract within every domestic jurisdiction of FIFA. So what the purport of that letter was to state exclusively and extensively what is expected in every footballer's contract in every domestic jurisdiction where FIFA has control. And in bringing that back home, I like to say that first and foremost, I need to highlight the contents of that letter, which was signed by Secretary General of FIFA back then, John Valke. And that letter states that effectively players' contracts must deal with certain issues and must take into consideration major things like the national law of the country and the collective bargaining agreements entered into between the players' union and the FA. And thirdly, various FIFA regulations like the RSTP, the FIFA Code of Ethics, and the various decisions of the Dispute Resolution Committee of FIFA and the rest of them. So three factors must be taken into consideration when players' contracts need to be drafted. Firstly, the national legislation in force. Secondly, the collective bargaining agreements entered into between the players' union and the FA. And thirdly, the various FIFA regulations, code of ethics, and most importantly, or very importantly, the decisions of the dispute resolution chambers. And that letter, which is an exhaustive letter, I must say, has led the bedrock for a lot of innovations, which we are currently seeing the RSTP. In bringing this back home in Nigeria or to Nigeria, the first thing I'd like to state here is the fact that when we mention the issue of collective bargaining, we have a players' union. And as it happens in the UK, the English Premier League, the players' union is a very strong professional union that negotiates certain issues in contracts for the players with the FA. And so with the FA and of course the various clubs. And they protect the interests of the players so profoundly that the players can actually go to sleep knowing that they have a union that works extensively for them. But if you come back home to Nigeria, I would not say that has been our case or that has been our current situation. We've had situations where players have died in the course of playing professionally in Nigeria. We'll go into the case of, some of us heard of the case of Igenewari George, the younger brother to Finidi George, who died courtesy of football of the Ghanaians and when he was playing for Bendel Insurance. Till today, I don't think anything was done concerning compensation to his family. And I have not heard of anything robust that the Players Union did, that is if there was one at the time. And secondly, we've also seen players die due to lack of proper medical and professional ambulance services on the pitch. And the Players Union have not done anything proactively to protect the interests of the players in the Nigerian setting. And some have argued, some schools of thought are of the opinion that the Players Union is effectively watered down, the effectiveness is watered down by some folks in the FA in order that what they should be demanding for in the interest of the players are not properly demanded for. Well, when institutions begin to crumble like it is in the Nigerian football setting, it is the grass that suffers, and the grass in this case are the professional footballers themselves. And secondly, I also need to speak extensively on the issue of dispute resolution. The letter, as written by John Valke to the various FAs or football associations, is to the effect that when disputes arise, that subject to the national legislation of the country with respect to labor laws, that such matters should be submitted to the dispute resolution chamber set up by either the FA or the football league itself. And it begs the question, in Nigeria, when last did the dispute resolution committee sit? That letter, and in essence, the various regulation, the transfer and status of player, demands that certain persons must be put in that arbitrary panel in order to give their verdict on issues that come to them. In Nigeria, there's a big problem. And what is the problem? Now, the concern is that most of the people who will be nominated to sit on those panels are club owners, are folks who are guilty of the very same issue they want to sit on and arbitrate upon. So it's tantamount to you being a judge in your own cause. So for me, it's a situation of where you're taking tubers of goats to be kept in front of, tubers of yams to be kept in front of goats. And all of them are wolves who have been involved in this same problem which the player wants to solve by bringing his dispute to the committee. It's a major problem where every person which is on the panel is guilty one way or the other of the issue that's going to be set in front of the panel by the player himself. I don't need the prophet to tell you he may not get justice, and they're always still to protecting the interests of the clubs as against the interests of the players. However, where the player, by some stroke of luck, is able to get justice by whatever way, enforcement and implementation is a big problem in Nigeria, and that is very key. It's a major drawback in the implementation or whatever is done in Geneva by FIFA or in Zurich by FIFA, and how it trickles down to the Nigerian setting. Enforcement of every regulation that has been brought up by FIFA. Another issue you need to quickly understand when these issues are being discussed is FIFA has on the international stage what they call the ITMS, the International Transfer Matching System, which is to the effect that every player transfer across football associations must be registered on that platform. On that platform. And every country is expected to have its own domestic transfer matching system. But if you come down to Nigeria, there are a lot of issues that have not been sorted out with the TTMS. Remember, Nigeria was the very first country to domesticate the ITMS, but as far as implementation is concerned, it's a major, major problem. Now, there is this enormous activity going on in the Nigerian Professional Football League. I don't know whether most of us know, but I will say it here. It's a podcast that I believe is going to go viral and people are going to learn a lot of things. Now, there's this tendency by clubs to sign two sets of contracts to their respective players. How do I mean? Since the MPFL rules, which is almost what is an adaptation of what comes from the RSTP, demands that every player contract must be submitted to the Football Association or the professional league. Clubs have devised a means to circumvent that procedure. How do I mean? A club goes into a contract to the player, agrees two sets of terms, and the term that is in tandem with what the MPFL rules demands is submitted to the MPFL. Well, the second contract is entered into with the club or with the player, which is what is binding between player and club. So you hear them say things like, the ones we are giving to the NFA is just to comply with regulatory procedures. What we are entering into with you now is what is going to bind us. So you get to see players who are being paid lower than the 150,000 naira, which is the stipulation by the MPFL. So you see players, the current rate is that you have to pay a player nothing less than 150,000 naira per month. There are players in the Nigerian Professional Football League who have signed away that sum in subsequent contracts that entered into with their respective clubs, while the NPFL believes that those players are being paid those sums. And it comes down to the issue of enforcement, number one. It comes down to the issues of the fact that most of these club owners are members of the NPFL or former members of the NPFL. And when that is the situation, it becomes very difficult for it to have proper enforcement of the rules. Unlike what is done in the UK, the Secretary General...
Start rounding up.
Okay, sir. Unlike what is obtainable in the UK, the Secretary General of the FA or the President of the FA, Chairman of the FA, is strictly into football administration. But in Nigeria, have people who are in club administration move into football administration and they juggle positions at that. And that doesn't allow for proper transparency and issues that should be properly aligned within the sphere of the Nigerian Professional Football League. Lastly, I need to talk on the issue of third-party ownership. Felix spoke on the issue of TPOs, third-party ownership, and now FIFA currently really frowns at it. The first thing that comes to our mind for me is the issue of Carlos Tevez and Javier Mascherano, their transfer from West Ham to leave from Corinthians to West Ham, and the role played by Kia Jarabchian, who owned the economic rights. And it caused serious furor, and parties were fined. But if you come down to the NPFL, players who have graduated from various academies down to the football clubs, the proper football clubs themselves, have the leaders and probably the owners of the academies they are coming from maintain or have ownership over the economic rights. So third parties are still having the economic rights of players in the Nigerian Professional Football League. And these are some of the terribly ingenious ways people have invented to circumvent the professional rules of engagement within the NPFL and by extension, the RSTP. So I think the Nigerian Professional Football League should do much more in dealing with these issues, these institutional issues. And I feel when we put our eyes into this, we will be better for it as a footballing nation. Thank you.
Nigerian Professional Football League. I'm sure someone who is listening, who is paying attention, should also be looking at the solutions to some of these teething problems. However, I just want to quickly chip in. With regards to the constitution of the NFF Arbitration Committee, sitting on disputes involving the clubs and the players, I think it is apt to mention that for employment disputes, the National Industrial Court has jurisdiction. So any player who is sitting down on his desk waiting for the NFF Arbitration Committee to be constituted and to sit is more or less wasting his or her time. This submission is actually anchored on the combined readings of, I think, Article 21 and 22 of the FIFA RSTP, which vests original jurisdiction on the resolution of employment disputes in sports on either the labor courts in that country or a dispute resolution chamber for nationals of that country, and then for foreigners of that particular country, for foreigners playing in that particular country, they can either engage in an ad hoc arbitration to settle the employment disputes, or they take advantage of the dispute resolution chamber, so long as the independence of that dispute resolution chamber is not compromised. So this is just the part I want to chip in, so that people should not sit back and swallow all this impunity, all in the name of, oh, we cannot take sporting disputes to the regular course. That is not the law anymore. The law is that you can approach the National Industrial Court or any other labor court constituted in that particular country. So it's no longer an excuse for people to fold their arms when they don't earn their salaries for months. So I think the listeners should be interested in listening to that. So without much ado, let me quickly invite Bidoin Aino to take us through a couple of the evolving clauses in sports contracts and the ingenious ways that parties seek to navigate through them. I will be dealing extensively with the image rights clause. So Doyin, you have the floor.
Good evening, listeners. So I'm just going to briefly talk about 3 clauses that, because of recent happenings in the football industry, being inserted in standard football contracts, over the years. So basically, I'm just going to quickly run through the morals clause, the force majeure clause, and termination for just cause clause. So starting with the morals clause, one of the earlier speakers said a little bit of morals clause, which basically is inserted in a contract to just putting it in the recent scandals in the sporting industry, and because of the scrutiny really that's put on players by the tabloids and social media and the new media world, clubs have been seen to insert what is called the morals clause in their contract. And what this seeks to do is to prevent a player or restrict a player from doing certain activities that are seen as immoral or that are not accepted in the society. And it also gives the club the right to take up any action, basically, where the player has done and committed an action that they refer to as immoral. So basically, we can call this moral clause, say, see no evil, hear no evil, and say no evil. So for example, a club can restrict a player from, say, maybe in a moral clause, for instance, now, it could look like something like a player is expected to dress neatly in public, okay? Or a player is expected to observe the highest level of integrity. For instance, now a player can be restricted from drinking alcohol in public, or from doing drugs basically in public. So you have that content in the morals clause. But one important thing of note is that, some of these clauses in player contracts are usually negotiable, but sometimes the player's contract, the morals clause rather, is usually not very negotiable. They're usually strict, and because sometimes they appear to be uniform for all the players in that particular club. Another instance, there have been instances of situations where clubs have included morals clause in contracts of players that are deemed to be maybe short fused. So maybe there are players that get angry easily or something like that. So this kind of moral clause will be used to restrict the player from doing anything that will be detrimental to the club. So there are so many instances. For instance, now there's Michael Vick, for instance. Michael Vick happens to be a player for the Atlanta Falcons. So sometime in 2007, he was arrested and charged with bankrolling. And so there was this illegal dogfighting ring of controlling this dogfight, and he was sentenced to 23 months in prison. Because of this, he lost his endorsement contract with Nike, and his club also went ahead to sue him for about $20 million, which he had received in bonuses. So these are the effects of breaching a morals contract by a player. So a player breaches a morals contract. There's so many effects, that can come out of it. One major effect is the termination of that contract by the club. Okay, so a club can terminate as one. The club can suspend pay for a period of time. So post salary for a period of time. Another thing is the club can ask the player to pay damages, for the breach of that particular clause, or pay basically some financial levy, put on the player, ask the player to pay such levy for the breach of that contract. So basically, this is just the long and short of a morals clause, and it's very popular now. It's very, very popular in the sporting industry right now. So I'll just move very quickly to termination on just cause clause. Now, the just cause clause is one of the exceptions in sports that allows a player to unilaterally terminate his contract. So usually when you talk about termination of contract, it's usually done by the mutual agreement of both parties. So say the club and the player, they both agree. But the termination on just cause allows a player to unilaterally terminate his contract. So when this clause is put inside the contract, especially you terminate his agreement. But there has to be some instances where this clause can be activated. So for instance, in a situation of outstanding salaries, so for instance, where a club has persistently refused to pay a player his salary, a player can activate this termination on just cause clause. So outstanding salaries fall under the umbrella of just cause. And the FIFA RSTP, just like one of the earlier speakers has said, provides that it has to be for a player giving the club about a 15-day written notice of their financial obligations. So now, when they refuse to do that, the player can terminate his contract. You also have a situation of maybe exclusion or deregistration. So for instance, you know the general principle that one can be a member of a club, one can be a player in a club, but not necessarily be fielded. Okay, so if your contract does not expressly state that you will be fielded or you appear in some of our games, the player cannot sue the club where he's not featured in any of their games, especially where the club keeps paying the player the salary. So the only requirement is for the player's salary to be paid, whether it's being fielded or not. But in a situation where it is included in contract that this player would say maybe train with the first team or always appear in every game of the first team or always play every game of the second team, and for some time the player has not been allowed to play in any of those games or is restricted from training with the first team. This is a situation of a just cause, especially where it is included in the contract. The player can activate this termination clause on just cause reasons. And lastly, you have the sporting just cause, which basically is for professionals, where a footballer or an athlete is a proven professional. He can rely on sporting just cause where for the duration of the season, he has not appeared in, or he has appeared in less than 10% of the club's games. Okay, so in that kind of situation, the player can activate this termination on just cause basis. And lastly, you have the force majeure clause. Now, the force majeure clause became very popular because of the advent of COVID-19. We saw that majority of the league games were put on hold. Majority of the sporting activities put on hold because of the advent of COVID-19. So now the question of force majeure came up to see whether COVID-19 actually happens to be a force majeure event. We also expected a lot of litigation and a lot of cases to come out of this, the effect of COVID-19 on sports, because a lot of contracts were put on hold because players found it difficult to actually perform their contract. So when you talk about force majeure, you're talking about a superior force. Okay, so it's a force majeure clause is basically protecting firms impossible or impracticable to carry out their duties in that obligation due to an act that is outside their own force or that is outside something that they could have controlled, okay, outside their own control. So when you look at it, when you look at the force majeure clause, and based on application, you see that the force majeure clause is really supposed to be express in the sense that rely on when referring to the force majeure clause, those events must be expressly stated. So if you tend to rely on, say, a hurricane, you tend to rely on heavy rainfall or some things like that, it's supposed to be expressly stated in the clause for players to be able to rely, or for parties to be able to rely on that clause. Now, an umbrella event that that parties usually put in the clause is an act of God. Okay, so they say for events, for instance, now the COVID-19 has been argued by some people to fall under the umbrella event of an act of God. So then you wonder that, how do you prove what an act of God is? How do you actually prove that this particular act was, beyond your actual control, or you couldn't actually control this, event? And lastly, before I round up, I'll just mention that, increasingly in the EU, there are times where the force majeure event, basically, relying on force majeure is not really accepted, in the EU. Not that it's not accepted, but you don't see it frequently in some of their contracts. And so sometimes this thing is not included. And there was this argument where the unfortunate incident of Emiliano Sala happened, and there was this argument that maybe the force majeure clause was not included, because in a situation of a death of the subject of that contract, the force majeure clause could have been activated to prevent the other party from basically fulfilling its obligation in the contract, basically because the contract became impracticable or impossible. But in a situation where a force majeure clause is not included in the contract, people usually rely on the common law principle of frustration. Although a force majeure clause is not included in this contract, it is obvious that this contract or the terms of this contract have been frustrated to the point that parties find it impracticable or impossible to actually carry out the terms of this contract. So I'll just stop here, giving this brief summary of these three clauses. Thank you very much.
All right, thank you very much, Doyin. Let me just quickly take you on the morals clause that you mentioned. You mentioned the fact that sometimes a club can insert a clause in the contract expecting a player to dress in a certain way. Doesn't that sound a bit subjective?
So that is something that can be negotiated and said, you know what, I'm only expected to wear this jersey when I'm on duty. So these clauses are a little bit negotiable when it comes to things that don't, augur well with the.
All right, let me put it in context. All right. Okay. You see a number of European teams when they are going for matches. You see them decked in the club's branded suits, going to the match venue, and then maybe a certain player who was not brought up to wear a suit, decides to maybe wear a tracksuit. Should that automatically activate the club's rights to invoke that morality clause in the contract?
Okay, sir. So I think that for that kind of situation, it will not be the morality clause that will be activated. It will be there's some other clauses that cover the duties of a player. So I don't think this will be about the morality clause, because the wearing a tracksuit does not mean the player is dressing indecently, as long as the player is not dressing indecently. So in that kind of situation, it will be some other contracts in the agreement that says that when you're going for any competition, you must be donned in the club's suit, or you must be donned in the club's special attire for that kind of particular situation. So most times the morality clause covers off-field activities and not on-field or not when they're on official duties.